Hello everyone, I am Vipul Puri, Deputy Director, Competition Commission of India. I am going to discuss the provisions relating to regulation of combinations, that is mergers, acquisitions and amalgamations. Please note that the views which I am going to express in this presentation and in the module are my personal views and do not reflect the views of either the Commission or any of its members. The discussions which we are going to have are going to be spread across 3 modules. In the first module, we would discuss the provisions relating to basics of mergers and acquisitions. In the second module, we are going to discuss the legal provisions relating to regulation of combinations and the economic tools which are required in assessment of combinations for the possibility or likelihood of appreciable adverse effect on competition. In the third module, we are going to look at the provisions relating to regulation of combinations in United States and European Union. However, before we go into any specific discussions, let me ask you a very basic question. The question is that what is the objective of competition law? Why are we studying the provisions of competition law? What is the job of competition law enforcement agencies? This discussion is going to be particularly helpful in developing the required philosophy for understanding the competition law and the discussions relating to regulation of combinations. So, our question was that what is the objective of competition law? And the answer is the basic objective of competition laws is to ensure that the process of competition is maintained and sustained in the market. Please note that we have used the term process of competition. That means, we are here to ensure that the competition process flows uninterrupted. It is not artificially impeded by any market force. Let us go to a related question then. Is the process of competition automatic? The answer is obviously no. Had it been automatic, there would not have been any requirement of competition law or the competition law agencies. Though we believe that most of our markets are free markets, still there are certain barriers which impede the process of competition. The barriers can be legal barriers in form of government policies. The barriers can be economic barriers in form of the cost of funds involved, or there can be technological barriers as well. Apart from all these forms of barriers, one more source of barrier is the conduct of market players. For the purpose of today's discussions, we are going to focus on barriers which are created by the conduct of market players. Now that we are focusing on the conduct of market players, this brings us to our third question. What is at the core of anti-competitive conduct? That is, what is required to cause harm to the process of competition? The answer is market power. Market power is at the core of any activity, any conduct that may create a harm to the process of competition. But the question is, what is market power? Market power can be defined as the ability on the part of a market player to act independently of the market forces of demand and supply. Let me take you back to the basic economics of class 12th, where you must have seen that price is determined by the intersection of demand curve and supply curve. That is, both demand and supply have an equal role to play in determination of price, but that is true only if the markets are perfectly competitive. In the absence of that, if a particular firm or a group of firms has market power, then in that case the price determination would not be simply a function of demand and supply. It will become a function of market power. That is, there are certain firms who have the ability of acting independently of their consumers or their other competitors. Going further deep, another related question which arises is, what are the sources of market power? The answer is on your screens. There are 3 sources of market power. The first source of market power, as you can see on your screen, is unilateral dominance. This basically refers that a firm over a period of time has grown organically to a size or has reached a position where it can now operate independently of the market forces of demand and supply. The second source is that if a particular firm does not have unilateral dominance, what it can do is it can enter into agreements. The agreements with competitors, which are called as horizontal agreements, or the agreements with the players operating at different levels of value chain, which is called as vertical agreements. The focus is that they can together operate independently of the market forces of demand and supply. That is to say, they can exert something called as collective dominance. Apart from agreements, the third source of market power is inorganic growth, that is growth through the route of mergers and acquisitions. So, in the overall scheme of things which we have discussed so far, now our discussions are going to be limited to the discussions on the aspect of mergers and acquisitions. In this backdrop, we would start our discussions on module 1. Let us go through our learning outcomes for this module. The module is focused on understanding the activity of mergers and acquisitions, that is, what are mergers and acquisitions. Then we will go to bringing out the various forms of this activity and the discussions on their merits and demerits from the perspective of merging parties as well as the economy. After the general discussion on M&As, the module goes into the concept of combinations, the scope of the term combinations as used in the Competition Act 2002. In order to create a foundation for development of thought process required for regulation of combinations, the module ends with the discussions on need and causes of regulating combinations. Now, let us begin with our first question, that why M&As? Why do firms enter into mergers and acquisitions? The basic reasons which can be ascribed to merger and acquisition is the quest for growth. As we can understand, there are two approaches to growth, organic and inorganic. Organic growth, which is also called as internal growth, is driven by the firm's own business activities such as innovation, development of new products, or by development of markets. On the other hand, inorganic growth or the external growth refers to growth in business operations or finances facilitated by the mergers, acquisitions and takeovers, etc. Of late, the merger and acquisition activity has really picked up in India, and a number of mergers and acquisitions have taken place for various strategic reasons. The reasons can range from the diversification, maybe in terms of product or in terms of geographic scope of operations. The reason can be the cost synergies, which can help in realizing the efficient scale and size of operations, or anything, but the underlying factor would always be the quest for growth. Now, you may wonder, what is wrong with the growth? What is the need for regulation here? The answer is that yes, while growth is a positive virtue and leads to a number of efficiencies, it may also cause an increase in market power of a firm, giving it the ability to indulge in anti-competitive practices. This negative impact of growth underscores the need for regulation. Now, we go to our second aspect of different forms of mergers and acquisitions and their treatment in competition law. There are different forms of M&A activity such as merger, amalgamation, acquisition, absorption, etc. These various forms either differ in structural form or the legal procedures or even the accounting. However, as far as competition laws are concerned, we are focused on substance of the transaction and not the form which it takes. Our focus is on the spirit of the transaction, and therefore, the form of transaction is completely inconsequential. In fact, the Competition Act uses a common expression called as combinations to refer to various forms of merger and acquisition activity. Now, after understanding that competition law is focused on substance and not the form of combination, the next question which arises is whether all mergers and acquisitions or all combinations which take place in India are required to be notified for approval, or is there a selective criteria for the same? The answer is that determining whether a combination is notifiable or not depends upon primarily three factors which are now on your screen, which implies that all the combinations are not required to be notified. In fact, those combinations which meet the criteria which we are going to discuss are only required to be notified. This is consistent with the principle of management by exception. What are those three factors which are relevant to determine whether a particular combination would require notification or not? The first criteria is the asset or turnover thresholds which are prescribed in section 5 of the Act. The second is the regulations which are issued by the Commission for regulating the procedure as regards the combinations, and the third criteria is exemption notifications which are issued by Government of India. We are going to discuss all these three factors in detail now. Let us begin with the first factor. The primary criterion for examining whether a combination needs to be notified is based on thresholds. The thresholds which are fixed on the basis of value of assets and turnover of the parties to the combination, or the group to which the parties belong, or on the basis of geographical scope of operations. Thus, there are multiple criteria even within the factor of thresholds. The notifiability of a combination can be determined based on number 1, asset size or turnover scale of the parties to the combination, asset size or turnover scale of the group to which the parties belong, the geographical operation of the parties, that is whether the parties or group operate only in India or they have operations in India as well as outside India. Please again refer to the table on your screen. If the parties are operating only in India and we are considering the assets and turnover of only the enterprises which are party to the combination, the value of assets required for notifiability of a combination is rupees 1500 crore and the value of turnover required is rupees 4500 crore. That is, if the combined assets of the parties to the combination exceed 1500 crore or the combined turnover of the parties to the combination exceed 4500 crore, then the combination would become notifiable. Please note that this is an either or condition, that is, a condition in terms of asset threshold or turnover threshold is sufficient enough to make a combination notifiable. Both the conditions rather need not be fulfilled. On the other hand, if we are applying the thresholds again on the basis of parties to the combination, but they have businesses in India as well as outside India, it would require assets, combined assets of $750 million, including rupees 750 crore in India, or a combined turnover of $2.25 billion, including at least a turnover of rupees 2250 crore in India, in order to make the combination notifiable. Now, if instead of applying the thresholds on the basis of enterprises, we apply thresholds at the level of group and the group has operations only in India, a combination would be regarded as notifiable if the value of assets of the group exceeds rupees 6000 crore or the value of turnover of the group exceeds rupees 18,000 crore. On the other hand, if the group has operations in India as well as outside India, a combination would be regarded as notifiable if the assets of the group exceed $3 billion, including at least rupees 750 crore in India, or turnover exceeds 9 billion US dollars, including at least rupees 2,250 crores in India. The next factor after the thresholds which we have discussed is the provisions which have been included in the combination regulations. In combination regulations, Schedule 1, certain categories of combinations have been included that are ordinarily not likely to cause an appreciable adverse effect on competition, and the notice for such combinations need not normally be filed. Let us discuss some of the items which are included in Schedule 1 of the combination regulations and normally do not merit filing of a notice. The first item of Schedule 1 is acquisition of shares or voting rights which is not leading to holding of more than 25% of shares or voting rights of a company where such shares are ordinarily held as an investment. Please note the term, the shares are held ordinarily as an investment. That means if there is a strategic reason for your acquisition, though the percentage shareholding is less than 25%, the combination may still be notifiable. Thereafter, an acquisition of shares or voting rights not resulting in gross acquisition of more than 5% in a financial year, which the acquirer or its group prior to acquisition has already got more than 25% or more shares or voting rights, but does not hold 50% or more of the shares or voting rights of the enterprise either prior to such acquisition or after such acquisition. However, this is subject to a proviso that such acquisition does not result in acquisition of sole control or joint control of such enterprise by the acquirer or its group. Another related exemption which has been included here is an acquisition of shares or voting rights where the acquirer prior to acquisition has 50% or more shares or voting rights and the transaction does not lead in transfer from joint control to sole control. An acquisition of assets which is not directly related to the business activity of the party acquiring the asset or made solely as an investment. However, this clause will not be applicable if the assets being acquired represent substantial business operations in a particular location or for a particular product or service of the enterprise of which assets are being acquired, irrespective of whether such assets are organized as a separate legal entity or not. Likewise, an acquisition of stock in trade, raw materials, stores and spares, trade receivables and other similar current assets in the ordinary course of business are not required to be notified in ordinary course to the Commission. Now that we have discussed two of the basic factors which go into determining the notifiability of a combination, we now move to the third critical factor which is going to have an impact on the notifiability, and this is the exemptions by way of government notifications. The central government is empowered to exempt the applications of provisions of section 5 to certain enterprises or to certain combinations. The central government at present has exempted the enterprises whose control, shares, voting rights or assets are being acquired and it does not have either the assets exceeding 250 crore or the turnover exceeding 750 crores in India. This may be regarded as a de minimis exemption, that is, if the target enterprise does not have assets exceeding 250 crores or does not have turnover exceeding 750 crores in India, then the exemption is allowed and the notification in respect of such combination may not be filed even though the thresholds which we have discussed before are met. The central government has also exempted the banking companies in respect of which the central government has issued a notification under section 45 of the Banking Regulation Act 1949. In both the cases, the exemption has been made for a period of 5 years from the date of publication of such notification in the official gazette. Let us recapitulate what we have discussed so far. We have discussed that all combinations are not notifiable. The scope of the term combinations in Competition Act is not unlimited. Rather, it is to be determined in terms of thresholds, in terms of regulations issued, and in terms of exemption notifications issued by Government of India. As far as thresholds are concerned, the notification requirement further depends on assets and turnover of the parties to the combination, assets and turnover of the group to which the parties belong, whether the parties or group have operations only in India or whether the parties or group have operations in India as well as outside India. If any of the thresholds are met, the same may still not require notification if it falls under any of the items listed in Schedule 1 of the combination regulations. Notwithstanding any provision relating to thresholds and regulations, a combination would not be notifiable if it is exempted by issuance of a notification by Government of India. At present, the exemptions are allowed for de minimis cases and specifically for banking cases. Now, let us discuss some exercises to establish the understanding of the thresholds we have discussed. Suppose that the combined assets of an enterprise which are combining are rupees 1000 crore and the combined turnover is 5000 crores. Let us discuss whether this is notifiable or not. The answer is it is notifiable. Why? Because though the combined assets were less than rupees 1500 crore, but the combined turnover of the parties exceeded the threshold prescribed, which was 4500 crore rupees. Now, let us move to case 2. Suppose that the combined assets of the enterprises which are combining are rupees 2000 crore and the combined turnover is rupees 3000 crore. Again, the combination would be notifiable. Why? Because this time, though the turnover is less than a required minimum of 4500 crores, but the asset exceed the required minimum of 1500 crores. Now, let us move to another case. Listen, the combined assets of the enterprises which are combining are 1000 crores and the combined turnover is 5000 crores. The turnover of the target is 700 crores and assets of the target are 300 crores. If we look at the thresholds, the combination is notifiable because the turnover exceeds rupees 4500 crores. However, with the additional information we are given, we can easily deduce that the de minimis exemption in this case will be available, because even though the assets of target enterprise exceed 250 crore, its turnover does not exceed 700 crore. Therefore, by virtue of exemption notification issued by Government of India, the notice in this respect will not be required. Now, let us move to another related case. The combined assets of the enterprises which are combining are rupees 1000 crore and rupees 5000 crores. The turnover of the target is 700 crores and assets of the target are rupees 300 crore, and it is a case of merger or amalgamation. Please note, this exercise is very critical. This particular case is very critical to focus on a very minute observation. The exemption notification which has been issued by Government of India is for cases involving acquisition of shares or voting rights. That is, the cases which are covered under section 5A and section 5B of the Competition Act. However, the same is not applicable to the cases which are covered under section 5C of the Act, which relate to merger or amalgamation. Now, for the fact that this is a case of merger or amalgamation, the exemption notification would not be applicable and the combination would be notifiable. Now, let us look at one more case. The combined assets of the enterprises which are combining are 1000 crores and the combined turnover is rupees 5000 crore. The acquirer already owns 60% of the share capital of the target and has the sole control and plans to increase his shareholding to 80%. Now, this is a case which falls in the second item that we had discussed relating to combination regulations. The acquirer already has more than 50% of the shares, and it has also been clarified that the acquirer already has sole control. That means with this additional shareholding, which is going to increase by 20%, it is not going to change the status of control, and accordingly the transaction is not notifiable. Now that we are through with understanding of mergers and acquisitions in general, forms of M&As and the scope of the term combinations as per the Indian Competition Act, let us now understand the merits and demerits of mergers and acquisitions for the parties and the economy in general. Let us begin our discussions on merits and demerits by first looking at the firm specific merits. That is, what exactly do the firms gain or try to gain when they enter into mergers and acquisitions. The first straightforward gain to a firm is growth of business operations. As we have discussed before, that the mergers and acquisitions have the potential to contribute significantly to the growth of business operations in terms of activity, that is turnover, and resources, that is the asset base. You may look at a number of examples of mergers and conclude that the driving force has been the growth. There may be a number of instances in which it may be pointed out that suppose a company is trying to enter a country. Suppose there is a big MNC who is trying to enter in India. It would require not only the manufacturing capabilities, but also the distribution channel. Now, if there is an Indian firm which has a significant distribution channels existing, it might be prudent on the part of the firm entering India to acquire a firm and benefit from the established distribution channels. It will immediately give rise to its business activity and be a good thrust for turnover. Apart from growth, the other aspect which is related to growth is the cost advantages. A firm which is operating at a larger scale stands to benefit from the reduced average fixed cost of production as well as the average variable cost. The cost advantages may accrue due to: number 1, economies of scale. With increase in production volumes, it becomes possible for a firm to utilize its fixed assets in a more efficient manner. As a result, the fixed cost gets distributed over a larger production base, leading to fall in average unit cost of production. The second cost advantage may accrue due to synergies in operations. The presence of synergies implies that the value of the combined firm will be more than the sum of the values of individual firms. The synergies may be a result of vertical integration of firms, which allows it to gain a better grip over the production process, or due to a merger leading to integration of complementary resources. The cost advantages may also occur due to the financial synergies. The debt servicing capacity of a firm may go up to a consequent to a merger, and it may allow a firm to make use of cheaper source of capital, that is debt, in its capital structure. This will help in reducing the weighted average cost of capital and increase the value of the merged entity. Another important merit to a firm is diversification. Diversification implies diversifying the operations, reducing the risk profile to enter into unrelated businesses. That is to say, the conglomerate mergers. The unrelated businesses can be established on the basis of the product areas or the areas of operations, or can also be established on the basis of differences in geographical scope of operations. For example, a firm having operations in India may look to acquire a firm which has operations in, let's say, United States, to acquire a global footprint and to benefit from the state of competition in that part of the world. However, Now that we have understood the merits, we should also understand that there are certain demerits which a firm has to face when it chooses merger and acquisition as its growth strategy. The first demerit is that there are problems in integration of firms. The mergers and acquisitions are driven by potential synergies that they offer. However, at the core of this is an assumption that a firm will be able to achieve seamless integration of their resources. There is always some difference in working cultures of the merging firms, and this may hamper the process of integration. As a result, the desired efficiencies may not be realized. Similarly, there are key valuation issues. The entire process of merger and acquisition is based on underlying assumptions, and it is very possible that the actual outcome may be quite different from the planned outcome. Therefore, if the valuation has not been in consistence with the economic rationale or the economic scale of advantages which a firm hopes to achieve, then the entire exercise would not be value creative, rather it would be value destructive for a firm. Now, let us discuss some merits and demerits from the perspective of the industry or the economy. The first merit for an industry or an economy is in the form of consolidation. We know that the mature industries and economies are characterized by limited growth resources. The state of increasing costs and stagnant revenues may lead to a trend of merger and acquisition activity. The industry consolidation would result in such cases in optimizing the operating scale. The second merit for industry or economy is innovation. Though this merit is mainly for merger and acquisition activity in technology areas, it is equally applicable to the mergers and acquisitions in other areas. The mergers and acquisitions may lead to coming together of complementary technologies that may foster development of new techniques or new products, resulting in lowering the cost of the products or enhancing the consumer choice, which is particularly relevant to consumer welfare. Now, what can be the demerits at an economy level? The first demerit, which is our chief focus, is the adverse effect on competition. Mergers and acquisitions, especially horizontal, lead to decrease in competing market players. This reduction in number of competitors may adversely affect the degree of competition and lead to accumulation of market power with the merged entity. This is going to be our chief focus of discussion in our module 2. Lack of economic growth impetus. The organic growth process involves substantial investment in new assets and creation of new jobs, while in case of inorganic growth, the growth of a firm does not lead to growth of industry and economy in the same proportion, as the process merely leads to change in ownership of the resources rather than augmenting the resources for an economy. With these words, we complete our discussion on merits and demerits of mergers and acquisitions for an individual firm or an economy as a whole. Now, this brings us to our last section of this module, that what is the need behind regulation of combinations. The need behind combination of regulations is to prevent the unilateral and coordinated effects. As I have stated in the beginning of this module, that there are three sources of market power. The first source of market power is unilateral dominance, that is, where a firm is big enough to operate independently of its market forces of demand and supply. And the second is the collusion or the coordination in form of agreements with competitors or the agreements with players who are operating at different stages of value chain. Both these two aspects, that is the unilateral possibilities as well as the possibilities of coordinated increase in market power, is inherent in the concepts of mergers and acquisitions, and that is why the terms which are used in context of regulating combinations is the unilateral effects and the coordinated effects. The proposed combination may lead to generation of unilateral market power, or it may create certain factors which are conducive to cartelization or collusion, and this is where the combination need of regulation arises. A related question on regulating combination is that why are we regulating combinations on an ex ante basis? The basic reason which can be given for the same are: number 1, prevention is better than cure; number 2, ex post remedies would be very costly; and the third and most significant is that if the mergers are not given a clearance on an ex ante basis, rather they are also subjected to ex post evaluation, then it would lead to introducing a lot of uncertainty, and this type of uncertainty is likely to harm business environment in a significant adverse manner. Therefore, it is important that the mergers are notified and regulated on an ex ante basis. In this module, we have covered up 3 parts. 1. What are the mergers and acquisitions generally? What is the scope of the term combinations as used in Competition Act? How is notifiability or the scope of a combination determined? Thereafter, we have had discussions on merits and demerits of mergers and acquisitions. This discussion is required to create a ground for the discussions to follow, and in the last section we have discussed that what is the need for regulating combinations, and further why are combinations being regulated on an ex ante basis. Thank you.